All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer la fonction résiduelle de tribunal pénal est ouverte.
Please be seated. Before starting, I would like to apologize to all present for the delay, and I would like to make it very clear that tomorrow we will start at 9:30 sharp. Registrar, would you please call the case?
Thank you and good morning, Your Honor. This is case MICT 1355A. The prosecutor was Radovan Karadžić.
Thank you. Mr. Karadžić, can you follow the proceedings in a language you understand?
I do hope I will. It's number 6 should be. Yeah, I can.
Thank you. Let me now ask for the appearances of the parties, the prosecution.
Good morning, Mr. President, Your Honors. For the prosecution, Katrina Gustafson, Laurel Baig, Barbara Goy, and Ian Reid. Thank you.
Thank you, Ms. Gustafson. Counsel for Mr. Karadžić.
Good morning, Mr. President. I'm going to ask President Karadžić to introduce our team.
Excellencija, dobro jutro svima.
Good morning, Your Excellencies. Good morning to everyone in the courtroom. My main counsel is here, Peter Robinson, and then also we have Kate Gibson, Goran Petronijević from Belgrade, and Marko Sladojević, who worked with me throughout the whole case.
Thank you, Mr. Karadžić. Mr. Karadžić and the prosecution have both filed appeals against the judgment issued on 24 March 2016 by the trial chamber of the ICTY. In accordance with the scheduling order issued on 27 February 2018, the appeals chamber will hear today and tomorrow Mr. Karadžić's and the prosecution's respective appeals against the trial judgment. The case concerns the criminal responsibility of Mr. Radovan Karadžić, who, 1, was a founding member of the Serbian Democratic Party and served as its president from 12 July 1990 to 19 July 1996. 2, was president of the National Security Council of the Serbian Republic of Bosnia and Herzegovina, which was created on 27 March 1992 and held sessions until around May 1992. 3, was elected as president of the Presidency of the Serbian Republic of Bosnia and Herzegovina on 12 May 1992, and 4, from 17 December 1992, was president of the Republika Srpska and supreme commander of its armed forces. The trial chamber convicted Mr. Karadžić pursuant to Articles 7.1 and 7.3 of the ICTY Statute of Genocide, crimes against humanity, and violations of the laws or customs of war. In particular, the trial chamber concluded that Mr. Karadžić participated in a joint criminal enterprise to permanently remove Bosnian Muslims and Bosnian Croats from Bosnian Serb-claimed territory in municipalities throughout Bosnia and Herzegovina between October 1991 and 30 November 1995, and found him guilty under the first form of joint criminal enterprise of persecution, deportation, and other inhumane acts, forcible transfer, as crimes against humanity. The trial chamber also convicted him under the third form of joint criminal enterprise for persecution, extermination, and murder as crimes against humanity, as well as murder as a violation of the laws or customs of war. The trial chamber further found that from late May 1992 until October 1995, Mr. Karadžić participated in a joint criminal enterprise to spread terror among the civilian population of Sarajevo through a campaign of sniping and shelling, and convicted him under the first form of joint criminal enterprise of murder as a crime against humanity, and of murder, terror, and unlawful attacks on civilians as violations of the laws or customs of war. The trial chamber also concluded that Mr. Karadžić participated in a joint criminal enterprise to eliminate the Bosnian Muslims in Srebrenica in 1995, and found him guilty under the first form of joint criminal enterprise of genocide, persecution, extermination, and other inhumane acts, forcible transfer, as crimes against humanity, and murder as a violation of the laws or customs of war. The trial chamber also convicted Mr. Karadžić as a superior under Article 7.3 of the ICTY statute for persecution and extermination as crimes against humanity, and for murder as a violation of the laws or customs of war. Finally, the trial chamber concluded that between 25 May and 18 June 1995, Mr. Karadžić participated in a joint criminal enterprise with the purpose of taking United Nations personnel hostage in order to compel NATO to abstain from conducting airstrikes against Bosnian Serb targets, and convicted him under the first form of joint criminal enterprise of the crime of taking hostages as a violation of the laws or customs of war. The trial chamber sentenced Mr. Karadžić to 40 years of imprisonment. Mr. Karadžić advances 50 grounds of appeal. He requests that the appeals chamber vacate each of his convictions and enter a judgment of acquittal, or, alternatively, order a new trial or a reduction of sentence. The prosecution responds that Mr. Karadžić's appeal should be dismissed in its entirety. The prosecution advances 4 grounds of appeal. The first 3 concern alleged errors relating to the trial chamber's failure to convict Mr. Karadžić under the first form of joint criminal enterprise in relation to all crimes resulting from the removal of Bosnian Muslims and Bosnian Croats from Bosnian Serb-claimed territory in municipalities throughout Bosnia and Herzegovina between October 1991 and 30 November 1995, and for not convicting him of genocide on this basis. In its last ground of appeal, the prosecution alleges that the trial chamber abused its discretion by imposing a sentence of 40 years of imprisonment instead of life imprisonment. Mr. Karadžić responds that the prosecution's appeal should be dismissed in its entirety. I will now summarize the manner in which we proceed. On 27 February 2018, the Appeals Chamber granted Mr. Karadžić's request to participate in this hearing alongside his counsel and co-counsel by addressing grounds 28, 34, 36 to 39, and 45 of his appeal. It is for this reason that Mr. Karadžić is seated in the second row. I would like to remind both parties that the appeal process is not a trial de novo, and the parties must refrain from repeating their case as presented at trial. The arguments must be limited to alleged errors of law which invalidate the trial judgment, or alleged errors of fact which occasion a miscarriage of justice. Throughout the hearing, the parties may argue the grounds of appeal in any order they consider suitable for their presentations. The parties shall present their submissions in a precise, clear, and concise manner, and should also provide precise references to materials supporting their oral arguments. The judges, of course, may interrupt the parties at any time to ask questions, or they may ask questions following each party's submissions or at the end of the hearings. The Appeals Chamber is familiar with the briefs, and I would therefore urge the parties not to repeat them verbatim or to summarize extensively the written arguments. I would also like to remind Mr. Karadžić and his counsel for the parties to be particularly careful not to reveal any confidential information, including information that could identify a protected witness. As set out in the scheduling order, this hearing will proceed as follows. Today we shall hear the submissions in support of Mr. Karadžić's appeal for 1 hour and 30 minutes. After a pause of 30 minutes, we shall continue to hear the submissions in support of Mr. Karadžić's appeal for another hour and 30 minutes. Then, after a pause of 1 hour, the prosecution will respond for 1 hour and 30 minutes. After another pause of 30 minutes, the prosecution will continue its response for another hour and 30 minutes. Tomorrow, starting at 9:30 a.m., Mr. Karadžić or his counsel will have 1 hour and 30 minutes to reply to the prosecution's response. Then, after a pause of 30 minutes, we shall hear the appeal submissions of the prosecution for 30 minutes. Directly following this, counsel for Mr. Karadžić will respond for 30 minutes. Subsequently, the prosecution will have 15 minutes to reply. Finally, Mr. Karadžić will have 10 minutes for an optional personal address. Now I would like to invite Mr. Karadžić or his counsel to present his appeal. You have 1 hour and 30 minutes for this presentation.
Thank you, Mr. President. We're here today to ask you to overturn Radovan Karadžić's conviction and to order a new trial. It was 73 years ago in 1945 when American Justice Robert Jackson stood before a panel of judges in Nuremberg pleading his case before the very first International Criminal Tribunal. Since then, international criminal tribunals have been created for conflicts in the former Yugoslavia, Rwanda, East Timor, Sierra Leone, Lebanon, and Cambodia. Plans for internationalized tribunals are underway for Central African Republic, South Sudan, and Kosovo. And the Permanent International Criminal Court, with over 120 countries as members, sits just a few kilometers from here in The Hague. Other conflicts, such as those in Syria, Yemen, and Myanmar cry out for international justice. Much has changed since Justice Jackson pled his case before the judges at Nuremberg, but some universal values have remained the same, and none more important than the right to a fair trial. As Justice Jackson so eloquently said when the Nuremberg trial opened, we must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. So today in 2018, as I stand before you pleading the case of Radovan Karadžić, international justice is at a crossroads. Suffering and impunity continue to exist because powerful countries do not trust international criminal justice for themselves and their allies. To make international justice universal, international prosecutors have to put on scrupulously fair trials, and judges like you must be willing to call them to account when they fail. It was the 31st of July, 2008, when President Karadžić made his initial appearance in this courtroom. Today, almost a decade later, amazingly, he is more hopeful than he was on that day that he will obtain justice. Over the past 10 years, President Karadžić has fully engaged with the legal process here in The Hague. He followed the rules, showed respect for the judges, and despite many adverse rulings during the trial, came to regard the judges and even the members of the Office of the Prosecutor as people of goodwill. That is why he was so shocked and disappointed by the prosecution's violations of his rights during the trial, and that the trial chamber not only let them get away with it, but supplied by inference in its judgment what the prosecution failed to prove by evidence. It's a tribute to Radovan Karadžić's character that he stands before you today, once again respectful and full of hope. His endless optimism, his love for his people, his intellectual power and curiosity, his tremendous energy and capacity for work, and even his great sense of humor have kept him fighting for justice at full speed for the last 10 years, despite being locked in the United Nations detention unit. And so for the next 3 hours, I, my co-counsel Kate Gibson, and President Karadžić himself will passionately plead with you to overturn his wrongful convictions. Kate Gibson will address you for the remainder of this first session and show you how the trial went wrong and became an unwieldy, out-of-control mega-trial, begun with a presumption of guilt based on untested adjudicated facts and written statements, permeated by the prosecution's disclosure violations, and concluded with a violation of President Karadžić's right to testify in his own behalf. In the next session, I will return and take about 20 minutes to demonstrate step by step how the trial chamber's finding that President Karadžić shared the common purpose of executing the prisoners from Srebrenica was unsafe, unsound, and most importantly, untrue. Finally, President Karadžić himself will demolish the factual foundations of the trial chamber's judgment that claimed that there was an overarching joint criminal enterprise to create a homogeneous Serb state in Bosnia, and that President Karadžić favored and approved the shelling and sniping of civilians in Sarajevo. We will not have time today to address all of our 50 grounds of appeal, but we remain ready during this hearing to answer any questions that you may have on any of those grounds. What we're asking you to do in this case will not be popular in the short term, but it will advance the cause of justice long after we are gone. It is our privilege to represent Radovan Karadžić during this hearing and to make our modest but important contribution to international criminal justice. Thank you.
Ms. Gibson?
Thank you, Mr. President, Your Honours. President Karadžić has raised 26 grounds of appeal which challenge the fairness of the proceedings against him. And as you're aware, the remedy that he's seeking is that the appeals chamber order a new trial. I'll address you this morning on what we consider to be are the most compelling examples of what went wrong in this trial and when and why. And the why is particularly important in this case because there's a pattern or a theme that runs through all of the fair trial violations raised on appeal. There's a reason why the trial chamber took these shortcuts and made these decisions and committed these errors and consistently restricted the fundamental rights that had been afforded to all other accused at the ICTY. And the reason is consistently that it was led into these errors as a result of requests from the Office of the Prosecutor. To move straight to an example, there's one error in this case that really stands alone, that is so fundamental, so manifest, that alone it warrants a retrial. And without question, it's an error that begins and ends with the prosecution. President Karadžić was required in this case to choose between representing himself or testifying in his own defence. And by being put in that position, President Karadžić's right to self-representation was violated. Because at the first status conference in the Milosevic case, His Honour Judge May said, "The accused has a right to counsel, but he also has a right not to have counsel." And that's right. And in fact, the drafters of the statute placed this right to self-representation in Article 21. And so, on a structural par with other fundamental rights of the accused, like the right to silence or the right to have notice of the charges, the appeals chamber has called self-representation an indispensable cornerstone of justice. It might be unpopular, it might be inconvenient, but it's part of the statutory framework of this court. It's also part of a fair trial that an accused has the right to testify in his own defence. And the prosecution in the Blagojevich case has argued that the right to appear as a witness in one's own defence without question is central to the right to a fair trial, because the testimony of an accused is critical to an overall analysis of the evidence in a case. And so it's profoundly surprising that this trial chamber would have put the accused in the position of choosing between these two rights. Give up the right to represent yourself or don't testify. How did this happen in this case, in a case so late in the ICTY's history? It happened because the Office of the Prosecutor told the trial chamber, "This is what you should do." President Karadžić said, "I want to testify, and I want to testify in narrative form." After which the prosecution filed 6 pages of reasons as to why he shouldn't be allowed to. They said, well, it's not how the other witnesses were questioned. We've always done a question and answer format in this case. It would be unstructured, it would be inefficient, you would lose control of the proceedings, you shouldn't let him do it. Nowhere in their filing did the prosecution acknowledge that in imposing counsel on President Karadžić for the purposes of his testimony, they would be restricting a fundamental right of the accused. And by framing the issue in these terms, what's easier, what's more convenient, the prosecution led the trial chamber down the wrong path. And a few days later, in a short oral decision, the trial chamber adopted the prosecution's reasons and said, yes, you're right, we've always done question and answer, this will be more efficient, it means we keep control of the proceedings, and they imposed counsel on Karadžić for the purposes of his testimony. And so what happened next? On the 20th of February 2014, from transcript 247435 onwards, the bench and the parties were discussing how the questioning by President Karadžić's legal advisor would work. Could the legal advisor consult with President Karadžić during his testimony? Were there any restrictions on that? On what topics? Could President Karadžić tell his legal advisor, don't ask me certain questions? How would that work? And you can see from the transcript that midway through this discussion, President Karadžić says, I'm not going to testify. I've decided not to testify. President Karadžić was representing himself, faced with the choice between giving up that right or choosing not to testify. He chose not to testify. And putting him in that position, backing him into that corner, was an error. And for us, that's it. This was no longer a fair trial. Think about it another way. What if President Karadžić had been represented by counsel and the trial chamber said, actually, for your testimony, we think it's going to be more efficient and easier to control if you testify in narrative form. So for the purposes of your testimony, we're depriving you of the right to counsel and you must testify as a self-represented accused. What happened to President Karadžić is no less serious. This was a fundamental mistake. And the Blagojevich case, in which the prosecution argued so forcefully in favour of the right of an accused to represent himself, is useful for our purposes. Because in that case, the accused had fallen out with his counsel. They'd had some kind of a disagreement, and Blagojevich wanted to testify, but he didn't want to be questioned by this counsel. And the trial chamber said, no, you testify with your counsel asking you questions or don't testify at all. And he didn't. And on appeal, he argued that this had violated his right to testify in his own defence. And the appeals chamber said, no, the reason you didn't testify is because you were refusing to communicate with your assigned counsel. But what's interesting for our purposes is the dissent of His Honour Judge Shahabudin, who said the trial chamber was wrong to prevent the accused from testifying in narrative form, and it then violated his right to a fair trial with convicting him without him having been given an opportunity to be heard. And His Honour wrote that to require the acceptance of counsel is to imprison a man in his privileges and call it the Constitution. But unlike Blagojevich, President Karadžić had asserted his right to self-representation. This wasn't the case of an accused who said, I don't like my counsel. This was an accused who said, I want to represent myself. And that can't just be taken away. And it can't be taken away simply because it's easier or more convenient. And the prosecution argues in response that this was just a formalistic impairment of the right of the accused to represent himself. But the appeals chamber has been clear. Before this right can be restricted in any way, a trial chamber is required to do several things. It's required, firstly, to balance the restriction against whether or not there's a sufficiently important objective at stake. It's required to consider principles of proportionality and make sure that any restriction is carefully calibrated. And it's required to go no further than is necessary to accomplish that objective. In the Milosevic case, for example, counsel was only imposed after substantial and persistent obstruction to the trial proceedings and after the trial chamber concluded that the trial might not conclude if it didn't impose counsel. There was nothing like that in this case. Our trial chamber weighed nothing, calibrated nothing, and it certainly wasn't a harmless error because it meant that the trial chamber didn't hear from the accused. In a case where so much turned on what President Karadžić knew and when he was convicted without the trial chamber having heard his side of the story. And so the prosecution moves to its next line of attack, saying that President Karadžić's decision not to testify had nothing to do with the imposition of counsel. He decided to testify for unrelated reasons. What unrelated reasons? Does the prosecution know something that we don't? The prosecution isn't in the position to submit to this appeals chamber that it knows why President Karadžić took the decision not to testify. And look at the context in which he says, I'm not going to do this. I'm not going to testify. Certainly on its face, there's a clear link between the imposition of counsel and his decision. The prosecution's arguments don't stand up. This was a significant mistake that it led the trial chamber to make. It's the kind of mistake that results in a retrial. And our focus on this error shouldn't give the impression that this was the only time that President Karadžić's right to self-representation was violated. The entire site visit was held in his absence. And this was supposed to be a non-evidentiary site visit. The trial chamber said that it wouldn't hear any submissions from the parties. But again, the prosecution led the trial chamber into error because once on the ground in Sarajevo, the prosecution started to make submissions and in fact gave evidence about how particular sites had changed since the war. And then in Srebrenica, the prosecution at each of the locations gave a sort of mini closing argument as to what had happened in each of those places and characterised its evidence and discussed its exhibits. And the prosecution now argues on appeal, well, President Karadžić's legal advisor was there and he saw what was happening and he could have raised concerns. But the person to be raising concerns was the self-represented accused. But he couldn't because he wasn't there, because the site visit had been held over his objections in his absence. The trial chamber violated President Karadžić's right to self-representation by forcing him to choose that right at the expense of his right to testify. And putting everything else aside, this warrants a retrial. But of course, there were further problems in this case that had nothing to do with the fact that President Karadžić was representing himself. These problems had to do with its size. This case was unmanageable. This trial was unmanageable. And again, just like the violation of the accused's right to self-representation, the problem was caused by the prosecution. Instead of putting together a strategic and limited case that the parties in the bench could handle, the prosecution chose to charge President Karadžić for hundreds of events spanning a 5-year period throughout all of Bosnia. And it was a surprising choice because the warning signs were there. By the time President Karadžić was arrested in July 2008, the Milosevic trial had happened. And you had these former ICTY judges and ICTY legal officers who'd been open in saying that this mega trial against Milosevic had been a mistake. It had been a mistake to join the 3 indictments relating to Bosnia and Croatia and Kosovo. And they urged the prosecution to exercise restraint, simplify prosecutorial strategy, recognise that these mega indictments are counterproductive. But this advice was ignored, and in September 2008, the prosecution presented the trial chamber with this new amorphous indictment that joined 4 huge events and spanned the entire war. And President Karadžić told the trial chamber, don't do it. don't approve the indictment in this form, it will lead to the most complex and wide-ranging and trial in history. It will take years and years and years, and I want to bring a vigorous defence on the facts, and I can't do it on an indictment of this size. And he urged the trial chamber to proceed on just one of the 4 components of the case and to reserve its judgment on the other 3. The trial chamber declined, and it opened the floodgates for what was to be an absolute deluge of material that had been generated over the past 2 decades at the ICTY. Millions and millions of pages of documents that could be linked in some way to the charges in this case. The prosecution on appeal criticises the appellant for his use of numbers and figures and says that in our briefs we're often just recounting empty statistics. But in fact, numbers are appealing to us because they are what they are. They stand alone, and they immediately paint a picture of the size of the problem that we're talking about. So to give Your Honours some statistics, in pre-trial, the prosecution disclosed more than 1.2 million pages of material. After the trial began, the prosecution disclosed more than 550,000 more pages of material under Rule 68. The prosecution disclosed 388 witness statements after the deadline for the disclosure of witness statements. The prosecution was found to have breached its disclosure obligations 82 times. The trial chamber took judicial notice of 2,379 facts that had been adjudicated in other cases. These figures are incredible. How does someone even start to read and digest and analyse 1.2 million pages of evidence? What does one do with hundreds of thousands of pages of exculpatory evidence that land in the middle of the trial? And it's not surprising that the prosecution completely lost control of disclosure. There are no case managers on earth who could be across that volume of material and deliver meaningful disclosure on that scale. And they couldn't. And the prosecution's disclosure violations led to delay after delay. Prosecution witnesses came and went months or years before their prior statements were located and given to President Karadžić. And the trial chamber said to the prosecution, this is your fault. The size of this case is of your own making, which is partly true, but partly untrue, because as we've set out in detail in ground 6 of our appeal, the trial chamber had the chance to force the prosecution to make this a manageable trial. In October 2009, the trial chamber said it was gravely concerned about the scope of the prosecution's case and its effect on a fair trial, and it asked the prosecution to identify some charges or cites or incidents that could be reasonably dropped. And then it said it was disappointed when the prosecution only dropped a handful, but it still didn't force the prosecution to do a better job, to reduce the size of its case. Because in fact, disclosure violations were only the tip of the iceberg. The trial chamber was understandably rushing to try and get through all of these allegations in a reasonable number of years, and so took judicial notice of so many adjudicated facts and admitted so many untested witness statements that, in effect, the burden shifted to the defence. Without even having heard a witness, President Karadžić faced a mountain of adjudicated and accepted evidence that was so high, it was always going to be impossible to jump over. Separately, cumulatively, these violations mean that this trial was unfair, because the fairness of a trial is a delicate balance. even when the judges are of the highest calibre, even when the institution is inherently fair, the balance can tip very, very quickly. And it tipped in this case. And President Karadžić is now arguing in front of the appeals chamber that the only remedy for the fundamental mistake of proceeding on an unmanageable indictment is a new and fair trial. So, what happened? What went wrong after this mega indictment was approved? Starting firstly with ground 6 and the disclosure violations in this case. Vitomir Žepanić was the Deputy Minister of the Interior in 1991 and 92. He was on the prosecution's list of witnesses in this case, which meant that under Rule 66A2, his prior statements were required to have been disclosed by the 9th of May 2009. The prosecution then dropped him as a witness, and he was called by the defence, and he testified in February 2013. In December 2013, the prosecution disclosed the notes of an interview between Mr. Žepanić and the prosecution's chief investigator that had taken place in September 1996. In this interview, Mr. Žepanić said that the Bosnian government intelligence services had shelled their own civilians in a marketplace explosion in Sarajevo because they needed something to provoke hatred. Mr. Žepanić had been in the police department on the morning of the blast and had been shown intelligence by a police officer that an SDS member who was named had put the explosive device in a bakery and that television cameras were waiting on standby to record the explosion. And so this interview, disclosed 6 years after the deadline, supported the defence theory that the Bosnian government had been shelling its own people in order to trigger international intervention. President Karadžić didn't elicit this testimony from Mr. Žepanić when he testified because he hadn't been given the interview and he didn't know that the witness had this knowledge. President Karadžić called 225 witnesses in this case. Mr. Žepanić was one of the very few that the trial chamber found to be credible. This is a disclosure violation, unequivocal, and it's one of 79 disclosure violations listed in Annex D to our appeal brief. 79 times the prosecution's loss of control over disclosure meant that President Karadžić missed the chance to confront witnesses with relevant evidence or to elicit relevant evidence. What's important about this is not just that it happened, and not even that it happened on an unprecedented scale. What's important is how the trial chamber and then the prosecution responded to these ongoing and fundamental and manifest disclosure mistakes. For its part, the trial chamber was aware of the scope of the problem, and in February 2011, it raised its deep concern about the volume of potentially exculpatory material being disclosed and the impact that this had on President Karadžić's preparations. Recognising the problem is one thing, the first thing. But there was a disconnect between the trial chamber's concern and its actions. There are many meaningful remedies available to a trial chamber in this situation, and President Karadžić asked for them. The exclusion of evidence, the recalling of witnesses, hearing evidence, having an evidentiary hearing, giving the defence access to the prosecution's databases, forcing the prosecution to reduce the scope of its case to a size that it can handle. None of these were put in place. Instead, the trial chamber's remedies were limited to setting new disclosure deadlines or ordering the prosecution to explain why it hadn't disclosed, or when things got really bad, ordering the prosecution to produce monthly disclosure reports. These remedies had no impact on the prosecution's case, no impact on the presentation of its evidence, no impact on the prosecutors personally. And in effect, it created this culture of impunity because the prosecution started to realise that nothing was going to happen. Here's another exculpatory witness statement that we didn't look for in time. What's going to happen to us? Nothing. At worst, we'll have to explain it. In a cost-benefit analysis, why would you, as the prosecution, dedicate more time and resources to getting on top of your disclosure violations when there's no incentive to do it, because there's no consequence if you don't? And as the scope of the disclosure violations became apparent, the prosecution finally revealed in October 2010 that, yes, we certified that we were trial ready a year ago, but we didn't consider that the disclosure of Rule 68 material was subject to that. And in fact, we're only looking for exculpatory material proximate to the witness's testimony. This should never have been allowed to happen. The prosecution should have been disclosing this material from the moment President Karadžić was transferred to the custody of Tribunal in July 2008. There's always been an institutional reluctance at the tribunals to allow prosecution lawyers to come and work in the defence teams and vice versa. And that's a shame, because what's happened at the tribunals is that defence lawyers certainly don't appreciate what's involved in the disclosure of millions of documents. And prosecution lawyers have no conception of how impossible it becomes, how impossible it is when you're part of a defence team of 4 or 2 lawyers trying to keep your head above water and comply with your duties to the client and your duties to the court when you're facing repeated document dumps of tens of thousands of pages of exculpatory material during the trial. How impossible it is to formulate a defence strategy pre-trial when you've got no idea what the prosecution's evidence is and you haven't been shown what the exculpatory evidence is. And with a self-represented accused, the problem's even worse. And now we're in a position where the prosecution of the ICTY is arguing on appeal that there was no prejudice in this case because the 550,000 pages of additional Rule 68 material that was disclosed during the trial was of little or no relevance to Karadžić's defence and often duplicative of material already in his possession. But he still had to read them. They weren't disclosed under a cover letter that said, "Don't worry, most of these are irrelevant or duplicative." The prosecution should be unequivocally disabused of the notion that the content of documents is in any way relevant to a remedy when we're talking about disclosure violations in this volume. This trial was unmanageable. The trial chamber firstly allowed the prosecution to proceed on an unmanageable indictment and then created a culture of impunity that meant that the prosecution never dedicated the resources that it needed to get on top of this process. This was a fatal combination and it made the trial unfair. And this impunity will only end when a remedy is imposed that impacts the prosecution, a remedy like a retrial. Moving then to ground 7, which concerns the trial chamber's taking of judicial notice of adjudicated facts. Again, a direct consequence of the prosecution's insistence that it needed an evidential foundation of 2,379 facts from other case in order to present at trial. And when you work within the ICTY, the ICTR system for a while, it's easy to forget how extraordinary Rule 94B really is. And it's extraordinary, first of all, because it doesn't exist anywhere else. As Judge Kwon said, it's a new creation of international criminal procedure that does not exist in either common or civil law systems. And the drafters of this rule and the people who apply this rule have never hidden the fact that its goal is about efficiency. This has nothing to do with the fairness of trials. It has nothing to do with the even-handed presentation of evidence. The ICTR Appeals Chamber in Karamera said Rule 94B is about judicial economy. But what happens, really? What happens when a chamber takes judicial notice of an adjudicated fact from another case? The trial chamber, for example, takes judicial notice of the fact that 120 non-Serbs were killed by Serb forces on the 5th of August 1992 in Radovan Karadžić. What's the impact of that on the parties? What actually happens? Putting aside all the language about burden of persuasion and burden of production, what is the impact? Firstly, the prosecution is relieved of its burden for proving the actus reus of the crimes for that event. And secondly, the defence now has the onus to elicit evidence to rebut that fact. The burden shifts, that's clear, unless the defence gets up and goes out and investigates and finds evidence and presents evidence to contradict the fact that 120 non-Serbs were killed in Radovan Karadžić. That fact is a fact in this case. The burden shifts. The real problem is that the trial chamber that made the initial finding about the 120 deaths may not have heard any evidence to the contrary. That's the real danger here. And the appeals chamber was alive to that risk when it limited judicial notice of adjudicated facts to those other than those going to the acts and conduct of the accused. The appeals chamber said, you can't take judicial notice of facts that go to the acts and conduct of the accused because defendants in other cases where these facts are coming from have less incentive to contest those facts and might even choose to allow the blame to fall on someone else. And of course that's right. If I'm being tried in one courtroom, my focus is not going to be on finding and presenting solid evidence to exculpate someone else who's being tried down the hall. But actually, the concern of the appeals chamber applies to all facts, particularly if I'm a civilian authority and my defence strategy is to blame the military. Not only am I not going to be contesting the military's involvement in certain crimes, I'm probably going to be doing the opposite. And that's what happened to President Karadžić. The trial chamber took judicial notice of over 900 facts from the Buchanan and the Karadžić cases, and in those cases, the defence teams were concentrating on arguing that it had been the military and not the civilian authorities that committed the crimes. And so this mountain of 900 adjudicated facts is the very definition of one-sided evidence. And in fact, President Karadžić got the worst of both worlds because of his unique position as having been charged with responsibility for both the civilian and the military organs, because the trial chamber also took judicial notice of hundreds of facts from the trials of military accused, like General Galich, who was arguing that, no, it was the civilian authorities that were responsible for the crimes. And so President Karadžić's trial was flooded with hundreds of facts that would not necessarily have been contested by the defence teams in other cases, and in fact were likely to not have been. And that's what happens in reality. And that's one of the reasons that President Karadžić has used this ground of appeal to bring a constitutional challenge to the process of taking judicial notice of adjudicated facts. There's a reason why this doesn't happen anywhere else in the world. As a practice, it's unusual and dangerous. And of course, the counter-argument is, well, the accused still has the right to bring evidence to rebut those facts. It's not as if once they're in the record, they're final. If the accused wants to challenge them, he can. Yes, he can. If there are 10 or 20 facts or 162 facts, as there were in the Dragomir Milosevic case. When there are 2,379 adjudicated facts, no one could reasonably stand up in this courtroom and submit. If the accused wants to challenge them, he can. Think about it. You're a defence investigator. You're in the field. You've been asked to find evidence to contradict the fact that 120 non-Serbs were killed in Rastovac-Levica, and once you've done that, you can tick it off your list, and you've got 2,378 to go. And that's just the adjudicated facts. That's not even the prosecution's evidence. And yes, some of these will be background facts, and some of them the accused might not contest, but he still has to go through that process and check their veracity and make that call. And the volume was overwhelming, fact after fact, 900 from here, 200 from here, 400 from here. Throughout 2009 and 2010, the pile of adjudicated facts just kept rising. President Karadžić never had any hope of getting on top of them. He was starting from too far behind. The prosecution had too much of a head start. And then to compound this unfairness, the trial chamber in the judgment did what no other chamber has done before or since. If the defence did manage to bring evidence to contradict an adjudicated fact, the trial chamber then weighed the defence evidence against the fact and in almost all occasions preferred the fact. But that skips a step. You can't weigh an evidence against a fact. You can weigh evidence against evidence. Once President Karadžić had brought this evidence, that reopened the evidentiary debate into that fact, and the next step was for the prosecution to bring evidence in support of it. That's what the case law says. And so the trial chamber's application of Rule 94B actually exacerbated the error in this case. And anyone who tries to argue that procedures like Rule 94B are in the interests of the accused because it means the trials are quicker is badly misinformed. What's in the interest of an accused is to proceed on an indictment that's manageable, not unmanageable, that won't require admitting 2,000 facts from other cases just to lay the evidential foundation, that won't require giving the prosecution this kind of a head start in order to present its case. And what happens when you add these adjudicated facts to 148 witness statements that were admitted under Rule 92 bis? 148 prosecution witnesses weren't cross-examined in this trial. Their evidence went into the record untested and was presumed to be true. Which brings me to ground 16 of President Karadžić's appeal and the shifting of the burden of proof. No other accused at the ICTY, or in fact any other court, has been required to rebut so many facts presumed to be true. In a normal adversarial criminal trial, the prosecution and the defence start with an empty evidential record, a blank canvas. The first prosecution exhibit is Prosecution Exhibit 1. The prosecution bears the burden of introducing evidence, eliciting evidence to present its case. In this trial, the prosecution started from a position where thousands of facts and hundreds of pages of inculpatory witness statements were already in the record, presumed to be true. Facts about Serbs removing non-Serbs, attacking Muslim areas, executing detainees, beating civilians. The prosecution didn't have to prove its crime base. And It's trite to stand here in one of the last appeals before this institution banging the drum about equality of arms, but this is an equality of arms issue. Because the admission of these thousands of facts and hundreds of pages of inculpatory statements did two things. First, it relieved the burden on the prosecution, which is better resourced, of spending its resources to prove those facts. And then it put the burden back on the defence to spend its smaller amount of resources finding evidence to contradict those facts. And in the meantime, the prosecution is free to use the resources that it saved and dedicated them to other trial issues. So the inequality gets larger. The gap between the two parties gets larger, and that's the reality. And the prosecution says that judicial notice and Rule 92 bis statements are well-established trial procedures and have been held to be consistent with fair trial rights. Even if that's right, surely there must be a point at which the volume of untested evidence is so great that it makes the trial unfair. There must be a tipping point at which the burden shift is so significant that the process is no longer consistent with fair trial rights. In Stanisic and Samatovic, the trial chamber considered whether the large number of adjudicated facts would make the trial unmanageable for the accused. And if you're wondering what the large number of adjudicated facts in that case was, it was 392 in a case involving 2 accused. But this reasoning acknowledges that there would be a number. There'd be a threshold at which the volume of adjudicated facts makes this trial unmanageable. What if the trial chamber had admitted 10,000 adjudicated facts? What if 50% of the prosecution's evidence was untested? 75% of its evidence? There must be a point at which you can't just keep repeating these are well-established trial procedures. As with any well-established trial procedure, it can be implemented in a way that isn't fair. And the unfairness in this case is demonstrated very well by one of the prosecution's own arguments in response. The prosecution says at paragraph 143 of its response brief that, well, anyway, we had this massive body of documentary and testimonial evidence, so in any event, President Karadžić's defence was always going to have to be massive, so these 2,000 facts and these 148 witness statements, they don't make a difference. They don't mean the trial was unfair. That's an extraordinary submission. The prosecution is saying our case was so big that 2,379 adjudicated facts and 148 witness statements were just a drop in the bucket. The fact that the accused now has to rebuttal these facts doesn't make any difference because of how enormous our case was to start with.
Sorry. Could I ask you a question here? Did the trial chamber rely on this large number of adjudicated facts to enter convictions?
Thank you very much, President Maron. In fact, that is the second prong of the unfairness in this case. Our submission in ground 31 of our appeal is that the record was just so flooded with these untested witness statements and the adjudicated facts that they did indeed make their way into the judgment. And in fact, we've pointed to 36 convictions for scheduled incidents that rely solely or in significant part only on untested evidence. And we've argued in ground 31 of our brief that the appeals chamber should overturn these 36 convictions for having been improperly based on untested evidence.
So this is the basic prejudice that you allege?
The prejudice really exists in two parts. The first part is the convictions that relied upon untested evidence, but the second and the more global prejudice was that President Karadžić had to spend resources rebutting this volume of adjudicated facts that I'm describing under this ground.
Thank you, Ms. Gibson.
Thank you, Your Honour. Without appellate intervention in this case, there will be no limits on the admission of untested evidence at this tribunal. If this was okay, then everything will be okay. And the defence isn't blind to the pressure that was put on the organs of this institution to speed up trials, because that's why these measures like Rule 94B were put in place. And undeniably, they make the trials faster. But it's now gone too far. The pendulum has swung too far in terms of balancing efficiency and fairness. It should be firmly brought back. I'll move then quickly to a different topic concerning General Mladic and the trial chamber's error in refusing to compel his testimony in this case. That is the subject of ground 20 of our appeal. Much of this case, in the end, turned on what President Karadžić knew and when. He was convicted of genocide on the basis of information he had apparently been given and the timing of that information. Out of anyone involved in these events, General Mladic was best placed to know if President Karadžić, for example, had been told about executions in Srebrenica. And the trial chamber agreed with that and subpoenaed him. And so General Mladic came to court. He sat in the witness box. President Karadžić asked his first question. General Mladic refused to testify on the grounds of incrimination. And that was that. The trial chamber had the ability to compel General Mladic to answer the question, and it didn't. And this, we say, was an error. The trial chamber was wrong to ascribe more weight to General Mladic's rights as an accused than President Karadžić's right to defend the case, because Rule 90E exists for this very purpose. When a witness says, "I can't answer because it will incriminate me," the trial chamber can compel that witness to answer because Rule 90E says this answer can't be used against the witness. And because of this rule, Mladic was protected. And the trial chamber should have compelled him to answer. This wasn't peripheral evidence. This was evidence that went to the heart of the convictions for the municipalities, for Sarajevo, for Srebrenica. The prosecution says that this ground of appeal is based on the false premise that General Mladic would have been protected by Rule 90E. The prosecution says, and I quote, "Compelling Mladic to answer would have involved concrete risks to his right not to incriminate himself, notwithstanding Rule 90E." 2 months prior, the appeals chamber had confirmed in the Karadžić case that Rule 90E does protect the testimony of a witness who is also an accused. The appeals chamber looked at this question in detail in respect of Ptolemy's testimony and said Rule 90E works. Why is the prosecution saying that it doesn't? Because according to the prosecution, it couldn't guarantee that the Mladic trial team wouldn't have access to this testimony. The prosecution says no matter how hard we try, even if we create a Chinese wall between the Mladic trial team and the Karadžić trial team, we can't guarantee that the information won't be indirectly revealed. We are too highly integrated as an office. The prosecution is holding the Rule 90E procedure hostage. Its position is we can't comply with it. We're too highly integrated, too bad for the accused. In other cases, when the prosecution was trying to elicit evidence for its own advantage, it was absolutely clear that it could construct firm Chinese walls within the office. But now, when it's an accused who's trying to elicit evidence for his advantage, the situation is apparently different. If it's true that the prosecution can't comply with the confines of Rule 90E, then it should reorganise itself so it can. The rights of an accused can't depend on the level of integration of the office of the prosecutor, nor is it for the prosecution to justify the trial chamber's failure to compel this evidence just because the witness in question was General Mladic, who the prosecution says would have just given self-serving evidence, he wouldn't have been believed, and he would have been of little or no use to Karadžić. The trial chamber would never have issued a subpoena for a witness who would be of little or no use to an accused. President Karadžić wanted to ask General Mladic, did you ever tell me about executions in Srebrenica? Did we make a plan to terrorize the civilian population of Sarajevo? This was central evidence. This was the man who had this information. Whatever the answer, whatever the weight that was subsequently ascribed to it, President Karadžić had the right to get it. The trial chamber's failure to compel it was an error. And unfortunately, it was an error which was compounded by the trial chamber's refusal to hear the evidence of General Mladic's deputy, General Militic, which is the subject of ground 26 of our appeal. Like General Mladic, the trial chamber had issued a subpoena for General Militic's testimony. He then fell ill and the testimony was vacated. The subpoena was vacated. By the time that he'd recovered, the defence case had closed, and the defence team asked the trial chamber to reopen the defence case for 2 days to hear the evidence of this witness. The prosecution opposed the reopening of the defence case. The trial chamber agreed and made reference to the delay that it would cause. The trial judgment was rendered 12 months later. General Militic was patently an important witness. The trial chamber said that he was when it issued the original subpoena, and the prosecution said that he was when it asked for him to be heard viva voce. And that was right. And to give you just a few quick examples, the trial chamber found that by signing Directive 7, President Karadžić demonstrated the intent for forcible transfer in Srebrenica. General Militic drafted Directive 7, and he was prepared to testify that the draft included no such plan. The trial chamber found that President Karadžić restricted humanitarian aid to Srebrenica. General Militic was involved in the convoy approvals and in fact signed 7 notifications for humanitarian convoys in May and June 1995. The trial chamber found that President Karadžić closed the corridor for the column to leave Srebrenica and relied on this to convict him of genocide. General Militic monitored the corridor, monitored the column, personally denied the request to open the corridor, and then opened an investigation into what had actually happened. Trying to say now that this evidence isn't probative is not a serious submission. No reasonable trial chamber would have weighed this evidence against a delay in judgment drafting and decided not to hear it. And we invite the appeals chamber to look at the combined effect of these errors. The 3 people on the planet who knew most about President Karadžić's involvement in Srebrenica were President Karadžić, General Mladic, and General Militic. President Karadžić didn't testify after he was forced to choose between testifying and giving up his right to represent himself. General Mladic was subpoenaed and in the witness box, and the trial chamber chose not to compel his testimony. General Militic was ready to testify, and the trial chamber chose not to hear his testimony. President Karadžić was convicted of genocide with this huge gap in the evidence. A trial chamber's findings are only as good as the evidence it hears. Other trial chambers at the ICTY have bent over backwards to accommodate evidence of this relevance and probity. Our trial chamber wouldn't wait for 2 days. This was an error. It should be rectified through the ordering of a new and fair trial at which the testimony of President Karadžić, General Miletić and General Mladić can be heard. Turning then to a different subject and ground 23 of our brief, which deals with the privilege of war correspondence. President Karadžić's position throughout this case has been that the qualified privilege of war correspondence is not held by the individual journalist, but by the news agency for whom they work or worked. And so a journalist can't waive that privilege, it must be waived by the news organisation itself. 5 retired war correspondents testified for the prosecution in this case. Before each of them testified, President Karadžić objected on the grounds that the news agency in question hadn't waived the privilege that attached to their testimony. The trial chamber said, no, it's a matter for the journalists whether they want to testify or not. This was an error. In the United States, this question has been litigated, and the US Court of Appeals has held that the privilege protecting journalists in their news gathering functions is held by the news agency. In that case, it was CBS. What about the international courts? In May 2015, at the Special Tribunal for Lebanon, the prosecution asked for a summons to be granted in respect of a Reuters journalist who'd been in Beirut at the time of President Hariri's assassination. The first thing that happened was that Reuters engaged lawyers in the UK who opposed the prosecution summons on the grounds of privilege. And then when the trial chamber issued the summons, it was the chief counsel of Reuters News, together with these British lawyers, who filed the request for appeal. The news agency had the right to insist on the privilege of the news gathered by that journalist. And this makes sense because, as Reuters noted in its STL filings, news organisations which depend on their journalists being trusted for neutrality in all sides of a conflict may be reluctant to cooperate. And you can imagine why. If a former BBC journalist, for example, decides to give evidence against a particular accused, it's easy to imagine that this could lead to the perception in the field that BBC journalists are not neutral observers. And at best, this could make their job more difficult. At worst, it could expose them to reprisals. The choice shouldn't rest with the individual, but with the organisation that's responsible for the journalists that remain. It wasn't the right of these 5 retired war correspondents to testify in this way. The trial chamber was wrong to let the prosecution skip over this step when there was a larger issue at stake. And their testimony was essential to the convictions for Sarajevo and the municipalities. The remedy is to order a new and fair trial at which this evidence is excluded, absent a waiver from the news organisation involved. President Karadžić has raised a second ground of appeal about privilege, and this time parliamentary privilege, which is the subject of ground 24 of his brief. Parliamentary privilege is recognised in most states. Common civil law jurisdictions from Argentina to Ukraine recognise that statements made in Parliament cannot be used against someone in a civil action or criminal prosecution. And this widespread acceptance of this privilege is unsurprising because the rationale behind it is a good one. It's important that people can speak freely in Parliament. It means your political opponents can be offended by what you say, but they can't use the judiciary to silence you. President Karadžić addressed the Bosnian Serb Assembly as the SDS party president, and he addressed the Republic of Srpska Assembly as the Republic of Srpska president. The statements that he made in those sessions are relied upon throughout the trial chamber's findings on the existence of an overarching JCE and his role within that JCE, and the fact that he had genocidal intent. These speeches form a big part of this judgment, and the trial chamber held, while immunities and privileges may protect parliamentary statements in domestic jurisdictions, this does not apply in international criminal proceedings. So that's what ground 24 really comes down to. Should parliamentary privilege apply in international proceedings? And it's hard to think of a reason why not. Privileges don't just disappear just because we're in front of an international court. This is an evidentiary privilege, just like legal professional privilege or war correspondence privilege or doctor-patient privilege, all of which have been recognised by the international courts. What could be the justification for ignoring parliamentary privilege in an international setting? The trial chamber didn't offer one. The prosecution hasn't offered one. And in fact, it would undermine the purpose of the privilege in the many states that recognise it, that a parliamentarian should be able to speak freely without fear of prosecution, if that parliamentarian could then be prosecuted at an international level for what he or she said. Now, the prosecution has argued that the appeals chamber isn't entitled to decide this point because President Karadžić didn't raise it at trial, and in fact, President Karadžić admitted and relied on statements from these assemblies that are in his favour, and because the trial chamber's ruling was made in relation to Mr. Karadžić. Just a few points in response. The fact that the ruling was made in respect of Mr. Karadžić's statements doesn't mean that it wasn't a ruling of general application in this case. Clearly it was. Secondly, privilege can be asserted at any time. The discretion lies with the holder of the privilege. President Karadžić is now asserting it. And of course the appeals chamber has the discretion to entertain this point. There are many examples of the appeals chamber deciding issues that haven't been raised at trial, particularly in the case of a self-represented accused. And this is an important question. Can a person's statements in Parliament be used against him in an international trial? It's very likely to come up again, and it's in the interests of all of us to have an answer. And I can assure you, Mr. President, that I am entering the home stretch of these arguments. I see that it's come up to 11 o'clock. I probably have less than 10 minutes to go, so I'm at your discretion if I should take the pause now or continue.
I suggest you continue.
Thank you. Turning lastly then to ground 29 and the impact, if any, of the Supreme Court of the United Kingdom's decision in the Queen versus Jogee on J Ce3 at the ICTY. And this ground of appeal has gotten more interesting as the appeal has gone on, not least because Your Honours have admitted an amicus curiae brief from the counsel who argued this case in front of the UK Supreme Court. So we have several lines of argument running in parallel and a significant body of submissions from the parties. The arguments are well known to all of us, but as an overview, what happened in Jogee? Previously in the UK, an accused who was part of a plan to commit an offence could be liable for additional crimes if he foresaw that the principal might commit those crimes as a possible consequence of the criminal plan and then kept participating. So, in essence, J Ce3. In Jogee, the UK Supreme Court held that this standard had been wrong. that common law courts had been wrong to treat foreseeability as a legal standard for the mens rea of an accused in that situation. Foreseeability was just a factual consideration, not the legal standard. It was a factual consideration from which an accused's intent could be inferred. And this meant, in effect, that the position in the UK reverted to what it had been 30 years earlier, before the jurisprudence took what the Supreme Court called a wrong turn. The accused needed to have tacitly agreed to the principle committing these additional crimes if the occasion arose. Foreseeability, no longer enough. The mere possibility of crimes, no longer enough. And this judgment was huge news in the UK. But it didn't just come out of nowhere. For 30 years, barristers and commentators and practitioners had been arguing that to hold an accused liable for murder or for any other offence merely on the foresight of a risk is fundamentally unjust. And the discomfort arose from the fact that suspects were being convicted on the basis that they foresaw that a principal might do something, but without any specificity. Liability was being imposed on the basis of a possible outcome or the risk of a possible outcome, rather than an established criminal fault standard like knowledge or recklessness or intent. And so this standard had created almost an endless liability, because really almost anyone can foresee a possible outcome of someone else's behaviour, but that can't be enough to make you liable for it. And so Jogee was seen as an important correction to allow for liability of accused only when there's sufficient evidence to make that link. So what does this mean for us in this case, in this court? Firstly, we have to acknowledge that J Ce3 at the ICTY has been resilient in the face of nearly 2 decades of onslaught from defence counsel and academics and commentators. The arguments against J Ce3 are well known. I don't intend to repeat them today, but J Ce3 has withstood this attack and has been affirmed and reaffirmed in the jurisprudence of this tribunal. We are not asking the appeals chamber to throw out J Ce3 on the basis that it's incompatible with principles of personal culpability, or because it's ultra vires, or because it's unfair. We're simply saying that one national judicial system whose cases helped inform the formulation of J Ce3 in the Tadic case has identified one aspect of its application as having had been wrong. And in our view, that provides the impetus to revisit this specific aspect of the J Ce3 doctrine in this court. Not to throw out J Ce3, but to correct this misalignment in one aspect of this law, and not because the appeals chamber is bound to follow shifts in national law, and not because of the link between English joint enterprise and J Ce3, but because it's right. Because J Ce3 is now out of step with everything. And adjusting the mens rea standard would allow this court to make the same correction even in the last days of its operation. And those were the grounds that we wanted to address in this morning's session. Again, we've only addressed some of President Karadžić's concerns. The other fair trial grounds are in our brief. You have them. We don't intend to raise them. But we've tried this morning to demonstrate a pattern of the prosecution leading the trial chamber into error, framing the case in this way that was never going to be manageable, refusing to make it smaller, insisting on a huge amount of untested evidence, and mismanaging disclosure to the point that it overwhelmed all of the players in this story. but most significantly, telling the trial chamber that it could trample President Karadžić's right to represent herself because this would be more efficient, easier for everyone. The prosecution should be part of safeguarding the fairness of these trials. The prosecution should want these trials to be fair and should guide a trial chamber to make the decisions that are compatible with the rights of the accused. The prosecution in this case did the opposite, and the result was an unfair trial that stands so far apart from other cases at the ICTY that a retrial is warranted. Thank you, Mr. President, Your Honours.
You still have, I believe, till 11:25. I am sure you would want to use your time.
We certainly would, Mr. President. And I'm going to turn to ground 40, which is part of our appeal. I'm just going to need to have our PowerPoint show up here.
If I could just return for one split second to Ms. Gibson. You have raised arguments regarding privileges of journalists, arguing, if I understand, that the news organization may raise and do routinely raise claims of privilege. In the case now being discussed, the news organization did not raise objections or appear in any way. So how do you apply it?
The error that we identified on appeal was that the trial chamber should have asked the prosecution to ensure that the news agencies had been given an opportunity to waive the privilege prior to the war correspondent taking the stand. And in fact, that was raised before each war correspondent testified, and the trial chamber dismissed it. So the trial chamber took a different position and said, no, the privilege rests with the individual itself. So we're arguing on appeal that that was a legal error, and it led to an unfairness in this case, because it's not clear whether these news agencies would have allowed the journalists to testify because of the considerations of neutrality that were raised by Reuters more recently at the STL.
But the news organizations had an opportunity to make this claim of privilege, didn't they?
That we can't be clear about. It was certainly President Karadžić did what he thought he could do in that situation, which was to raise the issue. Whether the individual journalists went back to, I think it was Sky News and BBC, and said, I've been asked to testify as a prosecution witness. Should I talk to the in-house counsel? Can I do this? That is not something we're clear about. For all we know, the news agencies might have found out after the fact.
Thank you, Mr. Robinson.
Thank you, Mr. President. In ground 40, the defense has challenged the trial chamber's finding that President Karadžić shared the common purpose of executing prisoners from Srebrenica. That finding was the foundation for his genocide conviction. The basis for this finding is contained in paragraph 5814 of the judgment. It says that he agreed to and embraced the killing of the able-bodied men and boys as demonstrated by his conversation with Derenic on the evening of 13 July, as well as his subsequent actions. So there are two elements to this finding. There's the Karadžić-Derenic conversation and his subsequent actions. Now, Miroslav Derenic was the president of the STS party in the neighboring municipality of Bratanac, and the person who President Karadžić had appointed civilian commissioner after the fall of Srebrenica 2 days earlier. Let's look first at the text of the Karadžić-Derenic conversation. There's an intermediary relaying the conversation between President Karadžić and Derenic because there was no direct telephone line between Bratanac, where Derenic was, and Pale, where President Karadžić was, more than 100 kilometers away. This conversation took place at a time when thousands of prisoners from Srebrenica had been bused to the nearby town of Bratanac on the evening of 13 July, 1995. The intermediary says, Derenic, the president, is asking how many thousands. Derenic answers, about 2 for the time being. The intermediary relays 2, Mr. President, and Derenic adds, but there'll be more during the night. And then Derenic asks, can you hear me, Mr. President? And the intermediary tells him that the president can't hear you. This is the intermediary. Derenic then says, I have about 2,000 here now. And the intermediary says, Derenic, the president says, all the goods must be placed inside the warehouses before 12 tomorrow. Derenic says, right. And then the intermediary says, Derenic, not in the warehouses over there, but somewhere else. Derenic says, understood. Conversation ends. There's no recording of this conversation. We just have the notes of the member of the Bosnian Muslim Army who intercepted this call. President Karadžić agrees that he did have a conversation with Derenic and that it pertained to the prisoners captured after the fall of Srebrenica. But he says that somewhere else meant Batkovici, a prison in eastern Bosnia where prisoners of war were housed and regularly visited by the Red Cross, and where the prisoners from Srebrenica would be taken to be detained and not killed. In the Vasiljevich judgment, the ICTY appeals chamber stated that when a chamber is confronted with the task of determining whether it can infer from the acts of an accused that he or she shared the intent to commit a crime, special attention must be paid to whether these acts are ambiguous, allowing several reasonable inferences. The trial chamber concluded that President Karadžić ordered the prisoners to be taken to the Zvornik area and executed. How did the trial chamber infer that President Karadžić ordered that from that cryptic conversation we just looked at? Where did they get Zvornik from the words used by President Karadžić, somewhere else? Well, they got it from the testimony of Momir Nikolic. Nikolic was a Bosnian Serb army captain who participated in the Srebrenica killings and burials, made a plea agreement with the prosecution, and testified at several trials. The trial chamber that sentenced him and heard his testimony in the Blagojevich case, led by current mechanism judge Lou Dakin, found him to be evasive and lacking in candor. Nikolic testified that at a meeting in Bratanac around midnight on the 13th of July, Derenic stated that he had received instructions from President Karadžić that all of the Bosnian Muslims men should be transferred to Zvornik. According to Nikolic, in addition to Derenic, Police Commander
You
Dragomir...
have 5 minutes.
Okay, thank you. Police Commander Dragomir Vasic and Army Colonel Ljubica Biara were also present when this statement was made. Now, for the statement that Deranic said that he had received instructions from the accused that all of the Bosnian Muslim men being detained in Bratunac should be transferred to Zvornik, the trial chamber appended footnote 18024. And that cited the testimony of Momir Nikolic and his plea agreement, as well as the testimony of two other witnesses, Srbislav Davidovic and Milenko Katanic. So we ask whether or not this testimony of Nikolic is in fact corroborated. Well, Deranic is deceased. He didn't testify. Vasic was on the prosecution witness list, but not called. And Biara testified as a defense witness and denied even being in Bratunac on the 13th of July. So no other witness to the conversation corroborated. What about the evidence cited by the trial chamber, Srbislav Davidovic and Milenko Katanic? Did that corroborate Nikolic's testimony? This appeals chamber has already said that it does not. In ruling on our motion to admit additional evidence on appeal, you said that, having reviewed the excerpts of Davidovic and Katanic's evidence relied upon by the trial chamber, none reflect direct knowledge of the meeting or the contents of its conversation. So the trial chamber erred in finding that the testimony of Davidovic and Katanic corroborated Momir Nikolic. And it didn't even recognize that it had based that finding on Nikolic's testimony alone. That is a fundamental error. It's no corroboration that Nikolic was aware of the meeting or even present. That could still be true, and he could be lying about what was said. For example, suppose you, Mr. President, encountered Prosecutor Brammertz one afternoon as you were leaving the building. You greet each other and exchange pleasantries. And suppose at the same time a member of Sheshel's defense team came out of the defense room into the lobby and passed by. And suppose he later claimed that he overheard you and Prosecutor Brammertz discussing the merits of Sheshel's appeal. There might well be video footage of you and Prosecutor Brammertz talking together in the lobby, and it might even show that the member of the defense team was passing by. But that would be no corroboration of what was actually said. The same is true here. Maybe Nikolic was outside of Deranic's office, as he claimed, but the issue is the content of what Deranic said, and for that, there is no corroboration. The finding that President Karadžić was referring to Zvornik when he said the prisoners should be taken somewhere else rests entirely on the uncorroborated testimony of Momir Nikolic. We could take a break right now, Mr. President, if you'd like, or if you want me to continue for a few more minutes, I could do that as well.
We can take a break, and we will count this as your hour and a half.
Okay.
So we will.
Microphone, please.